A Nevada company told its cannabis application graders to never write anything down. Say it and forget it. Write it, regret it. That line was in the training manual. Then Missouri handed those graders nearly 2,000 applications and told them to decide who got the bill, the multi-billion-dollar industry. Last week, a unanimous Missouri appeals court told the state to hand Hippos LLC 13 facility licenses. 2 for cultivation, 6 manufacturing, 5 dispensary licenses. After finding the 2019 scoring process was inconsistent, undocumented, and in at least one case, performed by a grader whose qualifications nobody could verify. This ruling came just weeks after State Auditor Scott Fitzpatrick, I don't know why I can't speak, released an audit saying essentially the same thing. The scoring was erratic, the documentation was poor, the integrity of the entire process was suspect. My name's Patrick Nolan, this is Pat Talks Law. I have been covering the medical marijuana, the facility licensing process since before they began issuing the applications. This is nothing new. We told you that the process was screwed up back before they even started it. Corruption, rampant. Hippos fought this case for years. The company applied for licenses back when the Missouri Department of Health and Senior Services was just standing up the medical marijuana program, contracting with Wise Health Solutions out of Nevada to score the applications. Identical answers to the same questions came back with different scores. This isn't even a close call. That is a systemic malfunction. I call it corruption. People with connections to the company that did the scoring and the people that were setting up the process, who were also in the pocket of the former governor. It's amazing how that worked. Judge Jeffrey Bates wrote that this should never have occurred if Wise scorers had followed the instructions they were given. Neither the department nor Wise fixed it. I actually disagree with the judge. I think that the scorers absolutely followed the instructions they were given, just not the ones that were written down. Remember that initial statement? Say it and forget it, write it and regret it? They didn't write down the actual instructions. Hippos appealed the process, and the Administrative Hearing Commission tried to clean up the mess by picking the most common score for each disputed question. The appeals court called that approach completely flawed, and of course it was. The raw scores had no notes explaining why the graders gave them. No marginalia, no reasoning. The commission was just guessing which number was right based on frequency. And the court said so plainly, quote, "The conflict in these unexplained scores cannot be reconciled by simply assuming that the more common score for a particular answer is the correct one." The state's defense collapsed from there. Hippos brought 2 expert witnesses, cannabis consultants who had collectively prepared 83 Missouri applications, with more than half of their clients winning licenses. Both testified the applications deserved higher scores. The department put up nobody to rebut them. No counter witnesses, no compelling analysis, and the court noticed this. The department offered no rebuttal to Hippo's expert testimony, the court wrote, and presented no other testimony showing why Hippos should not be given the higher scores. Department spokeswoman Lisa Cox told the Missouri Independent that the Hippos case was among the first that the commission heard, and that in later cases the department did provide expert testimony supporting its position. She said the agency is evaluating all options on appeal. That framing has a problem though, and at least one of those later cases used the same rescoring method the appeals court just dismantled. I've not been able to talk about these issues for a few years, but this is dead on. Then there's the grader. Wise was supposed to verify each scorer had relevant experience and background. For the woman who graded the questions Hippos challenged, nothing in the record showed that that happened. Nothing. No cannabis industry experience. No background in business evaluation or analytics. Okay, the department argued that she was a college professor with strong research skills. I don't buy it. The court didn't buy it either. Okay, the department also pointed out that she scored hippos a perfect 10 on 3 other questions and went unchallenged. You know, some people might call that a clever argument. It's a logical fallacy. Look it up. I'm not really swayed by that. No attorney is going to be swayed by that argument. And frankly, the court wasn't either. Okay, the training manual is what ties this all together. Wise explicitly warned scorers that emails, notes, and written materials would be discoverable in court. Think about that for a moment. Any emails, notes, or written materials would be discoverable. The training manual said, say it and forget it, write it and regret it. The training manual is telling them not to document the process. The only reason I have for that is because that process is corrupt all the way through. And frankly, the Department of Health and Senior Services needs to refund every single applicant's application fee, cancel every license they fucking issued, and start the process new. And pay damages to every entity they issued a license to. I wouldn't mind seeing some people in jail either. Now, the manual told them not to create a paper trail. The department's response to the audit claimed those sentences were taken out of context, and that scorers were actually encouraged to take notes. Look, the department has gone beyond the realms of credibility into flat out lying to the court. Okay? And the court's record shows otherwise. Okay, the commission went looking for any evidence of why scores were given. It found nothing. Because the system was designed to retain no information. Which is exactly what you want to do when you want to create a system where you can funnel multi-billion-dollar opportunities to a select few people that have paid for the process. It's called corruption. It's rampant with it, and it needs to be completely gutted. Seriously, people need to go to jail over this. The court's language is direct. The commission's decisions affirm the denials were arbitrary, capricious, and unreasonable, and not supported by competent evidence. The judges remanded the case with specific instructions, ordered the department to grant hippos every license for which it applied. Think about that. Every license hippos applied for has to be given. They don't reconsider it, they don't rescore it, and they don't consider the license caps. So hippos is now exceeding the license caps that were established. What about all the other applicants? Are we going to do away with license caps? The court did not directly address that. That wasn't before this court. Only the issue of hippos was. And that is a significant problem. See, what makes this ruling dangerous for the state isn't just the 13 licenses. It's the method. Nearly 850 unsuccessful applicants filed appeals. The Administrative Hearing Commission resolved many of them using the same rescoring approach that the appeals court just rejected. This fundamental flaw infected the entire scoring process, the court wrote. Now, the problem is that the court is looking at it as a flaw. It wasn't a flaw and it wasn't a bug, in my opinion. It was a feature. It was a feature that established and allowed and authorized the rampant corruption in the system. Okay. If the court's logic holds on further review, the Missouri regulators aren't looking at one bad case. They're looking at the question about whether the entire foundation of the state's cannabis licensing framework can bear weight. And the fact of the matter is, it can't. It has to collapse. And frankly, we probably need to bring in investigators from outside of the state of Missouri. Maybe feds, and we need an actual corruption case. And it wouldn't be a bad thing to look at pay-to-play Parsons in the process. Thank you for watching. I'm going to keep following these issues. I have for a while. I haven't been able to talk about some of them for a while. I'm sure you got the reason why in the text of today. However, We are going to continue resume coverage of Missouri's completely failed marijuana laws. We're also going to continue coverage of other civil rights issues, criminal law, and common legal issues that people face. Please feel free to drop a note in the comments. Let me know what you're thinking, what you think about the process, what you think about what happened, what you think about the impact that market had driving the prices up for all consumers in the state of Missouri. And if there's something that you think we need to be addressing, drop a note and let me know. Thanks, like, subscribe, and we'll see you again soon.